with Fanny, playing dirty tricks in the courtroom. She always picks, bending the rules. She'd know win, but I won't let her get under my skin. Down in Georgia, where the blues run deep, crooked justice, a secret they keep. But I see through her lies, I see the truth. Gonna make her pay for what she do. Fanny's got a reputation to uphold, but her tactics are shady. Story untold, she thinks she's clever, but I'm on to her game. I'll expose her ways and put her to shame.
Heyo! How are you all doing? Yes, a few minutes late, but we had some technical issues. But I'm here. Wee! Oh, hi, Steve. Hope you're enjoying your trip around the US. I am. Today, Dave took me downtown Detroit, and we went to have a Coney hot dog, 2 of them. Then we went to the Ford Museum, the first factory Henry Ford built. And we also had a floaty, which was amazing. And we met Commissioner Willis. And all of that is on my N.Starow road trip channel. We made an hour and a half live earlier today. So I'm having a good. And then we went down to look at sailboats. Let's see. Hello, Sue, J-Town, Wendy, Dave. Dave's not here. Dream, Ken's counseling couch, paralegal Liz, hi, and special Bendy Bros. All right. We ended yesterday about an hour and a half before the end of yesterday. In my opinion, nothing of interest really happened. It was more, and then I listened in on Catnot Williams this morning, and first hour and a half, or more of the same. We've seen it before. The lyrics, the thing is, and same arguments, and sadly the judge. Yeah, some lyrics will go in, and but then after one of the breaks, they started with the third party hearsay. Now that is interesting because, in my opinion, I don't even want normal hearsay in. Because I believe that most of the exceptions are bullcrap. And now they are talking about a third party hearsay, which means somebody who is not on trial and is not a witness is talking to somebody who is also not a witness, and they are talking about somebody. Even bringing it to court should be a mistrial, more or less. I mean, yeah. So what we are going to do is follow more about that. Now, I know that it seems to be a lot of time, but I promise you, There are breaks and dead air all over this. So we will try to get through this, and that is why I also started a bit earlier today. It's 8:15 p.m. Eastern Time, and yeah, let's go. Let's see here, so I get it correct. There. This should be.
So we're going to listen to the October 31st portion that's at issue.
Or go to www.visitfromhome.net to learn more.
Thank you for using Securus. You may start the conversation now.
Hello.
What's up?
Hey. Oh, what happened?
Lewis and Lloyd, I had to talk to Lewis.
Oh, okay. What is that?
I ain't good. Let him know. He behind me. Everything good. Lewis sent him down there so I can interview him to see if I want him. I'm like, so I can handle the tape.
Your Honor, I'm going to double check to make sure it seems unusually quiet.
Okay.
So I'm going to make sure the volume is maxed.
All right.
Thank you, Larissa. That's very sweet of you.
Just while we have a minute of downtime, I'm getting dispatches from colleagues that are not here.
Okay.
We wanted to make sure that we're all on the same page, and I guess the court acknowledged that the Mr. Kendrick's video that was discussed yesterday, the video of his interview, that everyone is on the same page that Mr. Kokomo and Mr. Steele were going to provide a copy of that video because it was not introduced at the time we were discussing it yesterday.
Okay.
And I think that everyone wants to make sure that you are on the same page that we will be supplementing the record with a copy of that video.
Right. And I think didn't we talk about that yesterday, that would be Defense Exhibit 1 to that motion? Yeah.
Yes, I thought we did, but
Yeah, we did.
Okay.
So it's admitted. The court reporter will await receipt of it.
yes, thank you.
Thank you.
Hello.
What's up?
Hey. Oh, what happened?
Lewis and Lloyd, I had to talk to Lewis.
Oh, okay.
Hey, hi, Fire Podcast.
I ain't good. Let him know. He behind me. Everything good. He said Lewis sent him down there so I can interview him to see if I want him. I'm like, so I can handle the tape. And I want him. If you feel like you can't, then don't waste my time.
Oh, okay. You want him?
But he talking like he handle like everything. He handle everything. He say he been working with all type of stars on all type of murder cases and all type of cases.
Mm-hmm.
Your PayPal. Oh, there it is. Holy crap. Holy crap. Sue, thank you so much. Thank you. $100 via PayPal. That is so sweet. Thank you so much. Thank you. Oh, thank you. Thank you. Thank you. Thank you. That is so nice of you. And with the words, keep up the good work. I will. I definitely will. Thank you. Okay. I get shocked and pleasantly surprised every time that happens. I hope I will never get used to you supporting, donating to the channel in this way. I hope I never get used to it. That I see super chats and donations via PayPal just stream by, and all you get is hey, thanks, and then move on. No, I mean, I'm so grateful. I really am. Thank you, Sue. Thank you so much. Mika's headphones. Semester started rough this week, being unmedicated. Thanks for the recaps, Nick. I hope everything sorts out for you. It's hell being without prescribed meds you need. It's not fun. And for the rest of you, I am really enjoying the United States of America. I knew I would, because the last time I was here, I enjoyed it. And it's not your fault, the people of the United States, that some airlines and some rental car companies are, how do I put this nicely? Bastards. That's a good word. That's a good word. All right. Let's continue with the trial.
I'm sorry.
Okay.
Can't hear that at all.
Your Honor, we're bringing over a Bluetooth speaker. I'll give the court what is being said so that at least we can discuss
Okay.
it. Mr. Stillwell says, when asked how he's doing, that Thug sent the lawyer down for me. I went and talked to him. He let me know he's behind me. Everything's good. Thug sent him down there so I can interview him to see if I want him. I feel like he can handle the case. Okay. I'll start over.
No.
Thug sent that lawyer down here for me.
That is not word by word what is said. That is Miss Love's interpretation of what is said. In my opinion, not proper.
I went and talked to the lawyer. He let me know he's behind me. Everything's good. Thug sent him down there so I can interview him to see if I want him. I feel like he can handle the case. And if I want him, if I feel like he can't, then don't waste my time. He's talking like he can handle it. He's been working all types of stars and murder cases.
All right, so the extent of it. Okay.
I agree with the state's rendition of what that says.
All
My objection is relevance and 403, specifically confusion of the issues. So to my knowledge, well, first of all, let me just say this. Factually, I think the state would acknowledge this. I did not represent Mr. Stillwell in 2015. I did not meet Mr. Stillwell in 2015. I am not the lawyer that represented that. I beat murder cases all the time and have represented all sorts of stars. So factually, this creates an impression to a jury that, and I know I'm not a party to this case, but I am linked inextricably with my client. This creates an impression to the jury. A reasonable deduction of the jury would be that he is talking about me, that Jeffrey Williams sent me, and let me just be clear, I have no information that Jeffrey Williams sent anyone, but Jeffrey Williams sent me to talk to Mr. Stillwell, and that this is just a continuation of Mr. Williams sent a lawyer. I'm here representing Shannon Stillwell in 2024, and all that is completely false. I know who represented Mr. Stillwell in 2015. I don't know if that's the individual that's being discussed, but it wasn't me. Furthermore, I don't know of any information or any evidence that Mr. Williams ever hired a lawyer on behalf of Mr. Stillwell or had any role in that. I don't believe that to be true, but the state has not provided any information. So this is misleading. It's confusing the issue. It creates the impression that Jeffrey Williams sent me, current counsel, and I'm continuing to work on behalf of Mr. Williams representing Mr. Stillwell. All that is false, and the state, I would hope, would agree that that any impression that it was me would be misleading to the jury. So I'm not sure what the relevance is, but certainly there's 403 issues that outweigh any probative value in this piece of information.
And Your Honor, just to add a bit more context to that, certainly we agree with everything that Mr. Sharp has said. We're going to have an objection as well, of course. We don't believe that that conversation that you're about to hear is, number one, irrelevant, that it advances any issue specific in this case. But more importantly, and the state knows this, I'm sure they do, there is no indication, and there, in fact, was not any attorney hired by Mr. Williams for Mr. Stillwell, Mr. Jackson. And so any discussion that the court would hear, that the state would intend to introduce about Mr. Stillwell talking to someone else about Mr. Williams sending an attorney down, or whether he's going to hire an attorney, or the fact that he did not hire an attorney for him, I don't see the relevance. And so that's just adding a little bit more context for the court.
All right, thank you. I'll hear from the state.
Yes, Your Honor. As far as the relevance goes, the fact that the alleged leader of the gang that Mr. Stillwell is a member of is securing for him representation for a murder that is alleged on this indictment, that we allege that other members of this gang committed. And the fact that we allege that, in part, one of the ways that the gang protects its members is to pay bail for arrested gang members and enterprise members, and to obtain and procure representation for them. The fact that Mr. Stillwell is relaying out of his own mouth that the alleged leader of YSL has sent someone down there, and the fact that this person has been, according to Mr. Stillwell, working with all types of stars and murder cases. And he is saying in one of his songs that he's talking about paying a lawyer, having beat a murder rap. I don't think anyone is going to get the impression that Mr. Sharp is the person who represented him. And even if they did, it doesn't in any way impact the 403 analysis, which Mr. Sharp bears the burden of showing that this information somehow or another is so substantially more prejudicial than probative as to permit its exclusion on 403 grounds. And he hasn't done that except to say that they...
I'm not sure that is the correct standard here. Since the state has the burden of proof, they have a tape where Mr. Stillwell has said something. If they know that never happened, then it's not evidence. Then it's just gossip. And it's not even gossip. It might be that Mr. Stillwell believed Mr. Williams would send him a lawyer, or he's just bragging to a girlfriend. I have no idea. What's in here is that Mr. Williams never paid for a lawyer for Mr. Stillwell. Never happened. Yeah, he ended up with the public defender.
I think that I'm the one, but Mr. Sharp's not the person or the proper inquiry around which to make that analysis.
All right. I mean, it doesn't actually say anything bad about any lawyers.
Well, I'm not.
Whether they think it's you or not, I don't see what that matters. I mean, if you want me to tell the jury that you want them to know that that wasn't about you because you didn't represent him in 2015, we could think about that. But I mean, it's definitely relevant evidence in that it makes the state's assertions more likely than they would be without that evidence. And
No.
Would you consider two things? I would like that instruction.
okay.
And second, would you consider taking out the lawyer said he represents all stars and is beating all sorts of, I mean, that's just lawyer puffery. And I don't know why that was said, but at the same time, I don't know why that would come in.
Go
ahead.
So as it relates to Mr. Sharp asserting or asking the court to assert or put before the jury evidence about him, I don't know that would be appropriate, but we can address it at a different time. And as for whatever the lawyer said about him representing all types of stars and murder cases, the fact that Mr. Stillwell made that assertion is the part that we believe is most relevant, because that means that it was important to him, and that's his belief. He's telling this person that he's saying he can handle it. He's been working all types of stars and murder cases. That repetition of that part of whatever the conversation was is the part that we believe is most pertinent.
Okay, and you're saying that then shows up in a music video, or what did you say about that?
with respect to the music video, I pointed the court's attention to the music video that we heard earlier.
Just that he had beaten a murder rap. Okay.
The
Pay
thing-
my lawyer 30 for that,
He had
to beat a
public
murder.
offender.
I
He
just beat a
didn't
murder
pay
rap, paid my
crap.
lawyer 30 for that.
Okay.
Your Honor,
Me and my slimes above the law.
I'm sorry. The problem is that there's nothing to indicate that there's any connection between that particular lyric that we saw in that video and this conversation that Mr. Stillwell is having with his significant other about an attorney coming to see him. And the important part to, pardon my seat, the important part, I think, to add into the analysis is that, Mr. Williams does not hire an attorney for Mr. Stillwell. And so there's been an association that's been shown already between Mr. Stillwell and Mr. Williams. And the fact of Mr. Stillwell having a conversation with his significant other, his girlfriend, about whether or not a friend of his or an associate of his is going to assist him in getting an attorney doesn't prove anything. I know they can argue whatever they want to argue, but there's got to be something to indicate that that's a reasonable argument, that they're discussing this, or Mr. Stillwell is having this discussion in the context of the quote unquote gang leader getting him an attorney as part of this overarching and ongoing conspiracy. And there's no evidence to indicate that. And then so for that reason, I would say that, again, I don't believe it's relevant at all. I think it does confuse the issue.
Okay.
I'd ask that you
I
got to hear.
understand the objection. It is admitted. I will give the instruction that it wasn't Mr. Shard if you want to come up with something like that. And otherwise it comes in. What's the next one?
To address my concerns about the idea that the jury would think that the lawyer in question is representing Mr. Stillwell currently, I'm probably going to include Mr. Botts in that too. It was neither Mr. Shard or Mr. Botts.
Okay.
I would also ask that in that instruction that it be added that it was not Mr. Steele who represented or who came down,
Okay.
quote unquote, to talk to Mr.
How about
Steele.
it wasn't any of the, what, I mean, was it? I don't know who it was.
Judge, I would,
Mr. Steele.
no,
Or myself.
we don't know that. And in fact, Judge, when we have in 2022 with the
Oh,
murder
you
with
asked.
respect to Mr. Steele, we don't. know.
Okay. Who entered an appearance, if anyone, on Mr. Stillwell's behalf in the 2015 case?
A gentleman by the name of Michael Dixon.
Anybody else?
No.
Was he-
At some point, there was, and just to give full context, a lawyer was not, the state keeps arguing that Jeffrey Williams hired this lawyer. A lawyer was not hired for a significant amount of time. He was represented by the public defender.
Okay.
I believe Mr. Dixon was the gentleman who entered an appearance and is being discussed here.
Okay.
And Your Honor, that's not what we said. We just read what Mr. Stillwell said, and that Thug had sent a lawyer down there. We didn't say someone had entered an appearance. He just said he talked to him. So we
Okay.
don't know who it was, and that was the point that I
Well,
was.
that doesn't matter because I'm not going to say it wasn't Mr. Shart that talked to Mr. Stillwell. I'm going to
Okay.
say it was none of these lawyers who represented Mr. Stillwell in 2015.
That's fine.
So do you want it to be Shart, Bot, Steele, or nobody here today?
Nobody here today.
All right.
An entry of
I'll finish.
appearance.
Shut up, love.
All right, y'all need to draft
You
it.
bat.
Give me a second.
Hey, cat. Yes, I'm turning into Cat Not Williams. Yes, I mean, look at the similarities. Hold on.
All right.
Oh no, so that. Yeah.
Next.
Judge, I'm going to try and play it through a Bluetooth speaker rather than play
Okay.
it through the.
Oh.
And this will be the November 9th, 2015 call at 1627. Just 1 second.
I need to. You guys in the chat make all this worth it. You. Oh. Thank you, chat, for being here. Thank you so much. I just have to say that over and over again.
What time are we playing?
I didn't give it's the call, the whole
Whole
call.
thing.
Now Valhalla is going to be so angry because we are brothers, and
Hello.
now I have a twin.
Correct.
Do it without the mic. I'm going to start where the call. I'm going to start where the call starts at 1 minute and about 27 seconds in. After the securist.
Oh yeah, that was so much better. Good work, prosecution.
Hello.
Echo.
It is.
Maybe it is better going through the microphone.
I'm going to try one more time. We had a microphone on. It does do that. Echo goes play.
Okay.
Cheers. Yeah, let's skip ahead a bit.
Honestly, you could transfer it. That might be easier.
Technical issues in a multi-million-dollar courtroom. And yeah, apparently, they might have paid $50 for the entire sound system in that courtroom.
I mean, some of it, but
I'm being encouraged to play it for Zoom.
do you have a transcript of it?
Not one that's really that accurate.
Okay.
They don't have any transcript of anything that is even remotely accurate.
I don't know what paper I got going on. These niggas tonight, you on hold and all that. Man, y'all just stop playing, bro. I know how to fight, bro. Y'all fuck at me, y'all cap ass shit, bro. I ain't with all this suck shit, bro. All this fake ass gangsta shit. I just on the street, y'all niggas get to my bro, everything good, man. Come on, man. You need some hold.
Hello.
And Judge, I'll point to the right of the screen where the court sees the lines indicating talk. That's the transcript that's coming up. It's sort of closed captioning. It's not the best, but that's what I was talking about.
Hold on. They are using closed captions as transcript. Have you all seen the closed captions? Now, even in the YouTube thing, when you do like a short or something, they provide a transcript if you kind of want to. It's nowhere near accurate. This is embarrassing.
Hello. The Juju, you on the phone, Juju? Hey, bro.
What up?
Man, what's up, man? You fucking nigga come out of this suck ass shit, bro. You shine, nigga, bro. For real, huh? I don't know what paperwork I had going on out there. Out there like he kicking like he's there with a lord or film, whatever he's doing. Man,
Who said that?
paperwork, these niggas, they don't know nothing about paperwork, man.
Who are they?
They tell me they shine.
What's their name? Who the big bro?
He's my hit big bro, Montana.
Bro, what channel ain't got no wisdom?
Hey, bro. Come here. My bro said Montana ain't got no rim. What time you'll be broke? Hello?
Let me holler at him.
Hold on.
Say pause it just a moment. I think this is important to note. At this point, a jail phone is being passed to a third individual. So we're about to hear a conversation between two individuals. Neither one of them are my client.
Okay.
Yeah.
Hold on, boy. You trying to have that something in that dope. Hold on. Ain't got no run, no flow or nothing. What you think about
Shit, bro, a green light and a floor is different, man.
Hey, I said here.
Bro. Hey, yo. I'm here, bro.
Bull.
He scared to get on the phone?
I don't know, man. He telling people to go to another nigga, man. These niggas market, bro.
Tell the nigga get on the phone.
Man, these niggas money, bro. I beat one of these fuck niggas up, bro. I ain't playing, bro. All that lame shit. Come holler at my bro, man. Hold on.
Hey, yo, homie.
Yo.
Rise and shine.
I shine, you shine, we shine. Hey, who your big fool, bro?
Yo, my big fool A1, dog.
A1?
Yeah, that's the big bro over Georgia, my nigga behind the G-Wall 5. It's insane.
You talking about behind?
Okay. Over here is the transcript. A1. Yeah, that's the big bro over word I can send. GW. Automated transcript. Oh Lord, this is so stupid.
G-Wall? A1 is on.
Yeah, A1 behind the G-Wall. Listen, 5. Listen, but we just had a 5 on 031 day, dog. My channel don't even have no realms, 5.
Hey,
my handle is busy. Hold on, bro. My handle is busy, 5. You can ask any nigga about me, dog. My name busy, 5. My channel don't got no what? Busy.
My son got the green light. Joe Shine gave him the green light over the whole right street, dog. I'm telling you, about the Joe Shine out.
Bro,
hey, look, you can three-way Joe Shine right quick.
Hold on.
Hey, bro, call Joe Shine, bro.
And for the love of all that is holy, if these are jail calls, they are always recorded. For the love of everything that is holy, people, if you have a criminally inclined relative or friend, please tell them to not even remotely insinuate crimes on a jailhouse call. It's not hard to not talk crime on a jailhouse call. It really isn't. I promise. You just don't talk crime on a jailhouse call. Poof. Oh. Coincidentally, in my merch store, I have doormats with I invoke my Sixth Amendment rights. Probably not for you here in the chat and you out there viewing this, but I bet you have a relative or a friend that cannot seem to stop talking. Okay? They need reminders. Yes, I do not give legal or jail calls advice that should be relied upon. Always consult a professional as your circumstances will be specific to your situation. Thank you, Casper. Thank you.
I ain't gonna keep going back and forth on nigga about them, bro.
He about to do it, You got to do it, man.
Bro, all this suck shit, bro. All that lame ass.
Bro, and who the fuck is saying that paper? Who put what the paper mouth?
I don't know. I think it ain't peeking that. Some nigga ain't peeking that though. You thought that ain't peeking? That's some murder ass shit.
Hold up, bro. I ain't about to do it on 3-way because I don't know how to work my mama's phone.
I got Josh. Hey, new baby.
Huh?
What her phone at?
Is it on?
Come on. What's your phone number, boy?
770-255.
Yeah. Yo.
9113.
Oh God.
And they said you on hold.
Yeah, I don't know what the hell that shit be about.
So what the fuck?
He said my sign is the green light, but he ain't say my sign ain't got no sign. He said he's green light.
Hey, Shannon
Bro, I
Graham.
know my channel. Find my channel used to be a green. No, he keeps telling nigga that. Bro, nigga know my channel. That nigga ain't saying my channel nothing bad about the nigga used to be blue, bro. My channel used to be brown. But that's the only my channel who shine fire and got the green light, dog. I'm telling you something I know, Shannon.
Okay. So somebody handed over the phone to a third party who is now talking to another person, and none of these who we hear now is a defendant. Yay. Ugh. Adrian, I don't know how old Adrian Love is. She might be considering her. She may or may not sacrifice baby lambs to Satan in her spare time. She might be immortal. I don't know.
Hey, boy, you need to pick it up. You need to pick it up. Where the other man? Where the other right now?
Yeah, we're going to find out from the lawyers what has been said, so I don't want to hear more of this. Yeah.
Curious. Goodbye.
Okay. So, just before I get started with the facts, I do not accept Ms. Love's assertion that I bear the burden of proving that prejudice substantially outweighs probative value. I believe that they bear the burden that it doesn't. They're the proponent of the evidence. That being said, what we have here, just in context, Your Honor, in November of 2015, Shannon was in a car on University Avenue. People shot into the car, tragically shot a young lady in the face, causing the car to crash and flip over several times. Shannon and the mother of his child were sent to the hospital. Shannon had a collapsed lung, several broken bones. While at the hospital, Detective Thorpe took out a warrant for Shannon for the murder of Donovan Thomas. Once Shannon was finally medically cleared, he was brought directly to Rice Street and dropped into this environment where he is wounded, hurt, and apparently, from the context of this phone call, individuals who seem to be associated with the Bloods started threatening him. I believe the context of this call suggests, if I'm being candid, it suggests that Mr. Stillwell calls an individual and asks him to tell the people that are in jail with him to get off his back and stop threatening him. It's clear from the context, and that's why I said what I said before we started with this is the idea that Shannon has to do this to survive, to stay in Rice Street, and now it's being used against him. I don't particularly care for. From the context of the call, it appears that Shannon is associated with G-Shine, which are Bloods. It appears that this individual he called for help communicating that he should not be attacked is associated as well. And then an individual by the name of Busy, who is locked up and apparently has been coming at Shannon, takes the phone and talks to the individual that Shannon called. They have an argument over blood politics. Shannon, there's no indication, has any part in that argument. I don't know where Shannon is at that time, but they have an argument over blood politics, over who runs this, who runs that. One individual thinks a gentleman by the name of Montana is calling the shots. The other individual is saying Montana doesn't have the authority to call the shots. But either way, the message is sent, Shannon is hurt, Shannon is injured, don't mess with Shannon. If this were a case about the G-Shine Bloods, my argument would be more difficult to make. This is a case allegedly about YSL and the alleged gang, criminal street gang YSL. Now, the state believes that they have this unbeatable argument, which they've brought out dozens of times already, and I'm sure they will again. Well, this is a hybrid gang, so therefore everything's relevant. No, it needs to be specific. They're saying that YSL is an entity, is a criminal street gang, and they're moving together to for a common purpose. This has nothing to do with YSL. This is internal blood politics, internal G-Shine politics, and quite frankly, my client just trying to survive in 901 Rice Street. Additionally, Your Honor, there's another concern that I have, and I would assume Mr. Adams has too. There's an individual, they're talking about who runs things. And one individual thinks Montana runs things. And then there's talk, again, when Mr. Stillwell is not on the phone at all, that a gentleman, and what I believe is said, is Dub. A jury hearing that could quite possibly misinterpret that as Thug. I was concerned, I heard that at first, but that is not the case. So that's another wrinkle into this, but I don't believe any of this is relevant. I believe it's highly prejudicial. It's not relevant to this case, I should say. It's highly prejudicial. It confuses the issues. And for a substantial amount of time, I did not note the starting time, but from a time till 8 minutes, Shannon is not even a party to the conversation. A certain time, I'll say around 6 minutes, but I didn't note the exact time, to 8 minutes, Shannon is not part of the conversation. And from 10 minutes and 40 seconds onwards, Shannon is not a party to the conversation. So it's unclear to me how this could be labeled statements by a party opponent and be admitted that way, or any sort of admission. Finally, Your Honor, I don't think I need to say this, but we have not been noticed that any of these individuals in this phone call are on the state's witness list, so we will not have the opportunity to cross-examine any of them.
All right. That conversation was clearly not testimonial.
I understand.
Your Honor, with the court's permission, I'll address the issue of burden in a moment, but I'd like to just start out by talking about the relevance. Mr. Sharp's assertion regarding the fact that this case is against YSL is, and therefore any calls that defendant Stillwell makes to have someone verify his blood gang credentials are therefore not relevant, is belied by the part of the indictment.
That was not Mr. Sharp's argument. You lying sack of human garbage. And you know it. But Miss Love can't stop lying. She's a compulsive liar. She does it, and I assume she doesn't even think about it. She just says whatever comes to her mind, no matter if she can show it in evidence or anything. And tell me this, if YSL is a blood gang or a part of the Bloods, which Miss Love has argued before, why are all the Bloods trying to kill Shannon? Why? Doesn't that speak against everything? And Mr. Stillwell trying to survive? It's so stupid.
Wherein the state asserts YSL claims affiliation with the National Blood Gang, and that some associates also claim the blood subset gangs, Sex, Money, Murder, and 30 Deep. We also go on within the indictment to discuss that YSL, as Mr. Sharp correctly stated, is a hybrid gang, that they actually have members of both Bloods and Crips. But specifically, we also assert that
you cannot have a gang with both Crips and Blood. You cannot. A hybrid gang, in their own definition, is a street gang that sometimes dabs into criminality. This is more or less the first time they are talking about hybrid gang being a gang consistent of both Crips and Bloods. Can you imagine the wars? And yeah, Sleep, a national blood gang? What? And I'm not stating I'm an expert in gangs or anything, but Bloods and Crips have been territorial. Let's just say territorial. For what is it? 50 years? More? There's no way they would think, hey, that YSL, let's get under the YSL banner and cooperate. No, folks. No. This is stupid on a whole new level, claiming that this is a hybrid gang where Crips and Bloods are a part of.
YSL associates often use and write the word black, which some of our witnesses have come forth and said means other things than what our experts have said, which is blood love all the time. The court heard within the context of this call a reference to G-Shine and Shine. As Mr. Sharp correctly asserts, G-Shine is also a blood gang subset. And Mr. Stillwell did not call someone to have the authorities come and have these people get off his case. He called another blood gang member. He had one blood gang member get on the phone with another in order to verify and validate his credentials as a bona fide blood gang member. So we would argue that Mr. Stillwell's words are words of a party opponent, that the words of the person who spoke on his behalf when he gave him the phone is an adoptive admission. He's making these assertions on behalf of Mr. Stillwell. And regarding, so in terms of relevance, our argument is that it very easily passes the low hurdle of relevance. And under 402, it's therefore presumptively admissible. And under 403, Mr. Sharp has not made any showing that it is substantially more prejudicial to Mr. Stillwell, such that the evidence would create a risk that defendant Stillwell would be convicted on a ground different from proof specific to the offenses charged in the indictment. Regarding the objection burden, Your Honor, I'm citing a line from Carlson on Evidence 8th edition that echoing federal authority, Georgia cases have placed the burden of demonstrating a violation of Rule 403 on the objecting party. But the case that I'll cite is State versus McPherson, 341 Georgia App, 871. And the pen site is at
It's
874.
Buffering.
Specifically, in discussing or analyzing whether or not there is a 403 reason to exclude the evidence, the court says that it finds no basis in the record to support the extraordinary remedy of excluding this evidence as unduly prejudicial, particularly given the strong statutory presumption of admissibility. There has been no showing that the evidence would confuse the issues, mislead the jury, waste time, or be cumulative of other evidence, or that the probative value of the evidence otherwise would be substantially outweighed by its prejudicial impact. And the fact that they're saying that there's been no showing.
But it's that because at that point it's on appeal.
When the court says,
Are you talking about at the trial court level, somebody didn't show, or here on appeal? Because that's
I see
different.
what the court said.
Yeah. I think it's.
If the court would give me a moment to analyze that
Nope.
aspect of that case.
No. You have had since November of 2022 to get your analysis completely correct. No, you don't. If you don't have that answer, then off you far. F something. And why are you wearing clown pants, Miss Love? Seriously? Why are you wearing clown pants? Yeah.
So the court references later on, in this case, there has been no showing that the potential witness's memory about the alleged incidents is either impaired or patently unreliable.
Mahadi de Jesus, You can't stand up and claim case law
Just
and
one-
not be able to anticipate judicial counter arguments. Thank you. Thank you, Mahadi. Thank you. This goes to the stupidity of the prosecution. She still has on yesterday's. Where did you spend the night? I know where she spent the night. She spent the night clawing herself to a beam in the roof so she could get some sleep.
So my reading of the case is that in this particular case, in the record that they're looking at, the record below, that there was no showing in that record, that the evidence would confuse the issues, mislead the jury, waste time, or be cumulative of other evidence, or that it would be substantially outweighed by its prejudicial impact.
All right,
Maybe I
well,
can answer the court's question.
be that as it may, 403 is a balancing test for the court to apply. So,
Ms. Love, are you done?
So I might have a little bit more, but if I may cede the floor to Mr. Sharp for a moment and come back.
okay.
How about you drop to the floor?
Two things. The state thinks it's relevant that Mr. Stillwell called someone else for help because he didn't call the authorities. He's in jail surrounded by the authorities, put there by the authorities. I don't know who he's supposed to call. He's around law enforcement. He's not being protected. As far as adoptive admissions, there are two phones. There's not an ability to have a party line in the jail where you can just pick up a third phone.
There's not supposed to be an ability to have any kind of cell phone, but
I agree.
anyway,
But in this scenario, another individual has the jail phone. The idea that Mr. Stillwell has adopted what's being said because he doesn't pummel the man with the phone, retake the phone and say, no, that's not true. When A, he's not hearing what's being said because he doesn't have said phone. B, we don't even know if he's next to that person. And C, there's not a phone for him to speak into to deny what's being said is preposterous. So it's not an adoptive admission.
so when does Mr. Stillwell, obviously Mr. Stillwell starts the conversation. He gets back on the phone 2 different times.
No, he actually is on the phone where Mr. Sharp stood up and said that from here on out, this is not going to be him. You hear him throughout that portion. You hear Mr. Stillwell throughout that portion talking on.
No, you hear someone making commentary in the background. There is no way in that you can assert that is Mr. Stillwell.
On the phone at various times. There is a point at which the talker on the person to whom he gives the phone
Right.
says he went upstairs, but then you hear the person to whom he gave the phone to speak on his behalf continue to assert his credentials, and his being the person now talking, his own credentials to speak on behalf of Mr. Stillwell and to assert his validity as a blood gang member throughout the call. So it's at various points, and I could go back and, obviously I could sort of demarcate those specific times where you hear Mr. Stillwell's voice, but there is not a point at which you stop hearing his voice 3 minutes in, and now it's only these two people calling or talking. And it's certainly not a point at which you expect Mr. Stillwell to pummel this man because he's making these assertions, when Mr. Stillwell plays the phone in the man's hand precisely to make those
And it's almost like he's an agent for Mr.
Yes.
Stillwell at the time. Somebody speaking on his behalf. I mean, I am going to overrule the relevancy on the 403 objection. I find these to be either admissions by a party opponent or adoptive admissions. And it also probably, to the extent neither of those covers it, I think both of those cover it. So.
Your Honor, will you grant me, for all of these rulings that do not go my way, will you grant me a continuing objection?
Yes.
Thank you.
I'm going to presume that we're under the Harvey rule. So I'm going to adopt
Haven't
everything.
haven't taken that back. So
Yeah.
that's what we're operating under.
All right.
All right. Let's move to the next one.
Yes, Your Honor.
Yeah, the Harvey rule is, the Harvey rule for you who are completely new. If nobody speaks against an objection or against the motion, The Harvey rule means everybody agrees. And that is in place until somebody disagree. On the defense side. That is the Harvey rule. And I got Mr. Bruce Harvey's business card when I was in Atlanta. So yeah, hopefully, I can get Mr. Harvey on stream sometime in the near future. Not about this case, the YSL case, but about his Second Amendment argument that he made on November 15th, pre-trial, when he tried to get the gun charges out. That was an amazing argument he placed forward. And Judge Glanville just more or less just said, well, that's not the current case law, so I can't, blah, 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 blah. But you could see on Judge Glanville that he had nothing to argue against. So all he did was, I deny this, blah, blah, blah. So I want to talk with Mr. Harvey about these Second Amendment things. Because I'm from Sweden. Everything is under license when it comes to guns. For example, if I get licensed to have a gun, I can only have it at home and at the range. At home, I have to have it, the gun, the pin, and the ammo separated. So no self-defense anywhere with that gun, because I really can say, Mr. Burglar, can you please wait a few minutes while I assemble the gun? No, that won't happen. So it would be a really interesting discussion about the differences in our cultures and stuff. And I believe Mr. Harvey, I will learn so much from him. But that is for another day, not today.
The next one is going to be November 9th, 2015 at 16:45.
Okay, I have no interest in these jailhouse calls, but I'm interested in the arguments in between.
So spooky.
Because I didn't note the time that we stopped it, but it was before the end of the call. So it's about midway, just a little after midway.
Louis Thomas, I take absolutely no offense. Our gun laws
I'm sorry,
are,
yes, that's it.
I'm used to them. Doesn't mean I think they're good.
Obviously, Your Honor, I won't repeat myself, but I'll incorporate my argument from the previous call regarding this being evidence that Shannon is G-Shine, not YSL. YSL has nothing to do with this call. And perhaps the state wants me to state specifically what the prejudice is, I guess, but I think it's pretty self-explanatory. It's prejudicial for the jury to be informed that my client has alleged gang affiliations that go beyond what is charged in this indictment. And so it is prejudicial to the evidence of my client's gang membership, to the extent, obviously, my stance is if it's evidence of membership in YSL and it shows that YSL is in fact a criminal street gang, I understand that would be evidence in this case, but evidence of gang membership outside of YSL is prejudicial. That's my argument. And really, Your Honor, this call is just a recap of what had transpired 18 minutes beforehand in the previous call.
So I'm interested in you addressing, is there anything additional in this call that's not covered in the other one?
So no, what this call did was belie the assertion that Mr. Stillwell wasn't making those assertions that were made by the person he gave the phone to. This is Mr. Stillwell, but this is it basically coming from his mouth that that's what he was doing.
Okay, well, I think it supports then that argument, but it doesn't need to come in separately to the trial.
Yes, Your Honor.
Okay, one
All right,
phone call
next.
out. Yay.
Your Honor, so are we saying that that's coming in or not coming in?
It's not cumulative.
Okay, one call coming out at least.
The next one is a short one. It's November 10th, 2015 at 1641.
Please avoid politics in.
Maybe we'll do this, and then if lunches are ready, we'll break for lunch.
Yes, Your Honor.
For you who don't know, infamous Sylvia just got demonetized just a few days ago because the YouTubes says she reuses content. Today, Legal Vices got a 7-day ban. He was getting a strike, claiming harassment, and the team of the YouTubes claimed that he posted a poll of sorts in his community section that was highly offensive and then deleted it. This happened while Jeff was asleep. There's no way he could have done it. But the YouTubes did not provide anything other than this happened. Okay, but can you show evidence? What did it? If you claim it was so insensitive, then show it. And they can't. So there are 2 channels that I happen to work with and people I have on my channel from time to time. So I'm a bit nervous at the moment because it seems like there is some kind of cancel culture going on where people are standing in false assertions to the YouTubes. So please, folks, I do not want to be yeeted. So keep a little more calmer than usual, if you wouldn't mind, than next week or so. I would appreciate it so much. Thank you.
Dear, November 10th at 1641. Twice. Okay, it's the same one.
Okay, I think there's another.
And I'm going to start, Your Honor,
which
at
I'm
around
going.
1 minute and 30.
Yeah, and
Hey, on third floor.
Yeah.
and it's a break. I don't remember why. So
That fuck nigga envy me anyway, man.
and still don't want to hear that call. So let's hear the arguments. This is just to save time.
I nigga had to big.
Hello.
But hey, man, that's y'all shit. Y'all choice. Y'all business.
I feel like I'm wild the clock. What I am.
You got shit.
I can take that.
What you said?
I said I feel like I'm round the clock. I feel well I am.
You have 1 minute left.
I'm stopping at 15 minutes and 5 seconds.
Okay. Your Honor, from 11:25 to 13:30, there is discussion about Woody, Kenneth Copeland, lying on my client, and having my client falsely accused of these charges. That is one aspect of what was just played. After 13:30, there is a brief discussion, as far as I'm understanding it, about the previous calls about the same subject as the previous calls, where we're talking about the Bloods, quote unquote, pushing up on Shannon. Very brief discussion. And then we get into stuff that, quite honestly, I'm not tracking or following, but I don't believe it has any relevance to this case. To the extent that 11:25 to 13:30, I would object. For the record, I don't think it paints my client in the best light, but if I'm forced to deal with that, I'll deal with it. That's 11:25 to 13:30, but I think that's the extent of what is admissible or what is relevant at all in this case.
All right.
So given that Mr. Sharp concedes that Mr. Stillwell's commentary about Kenneth Copeland and Kenneth Copeland telling on him and his expressed feelings about Kenneth Copeland are relevant, our position is that that portion, I agree, is relevant because it is talking about his feelings and his knowledge of a witness in this case. And the fact that the witness is telling on him about things that have to do with this case, we would argue as well that that is relevant and therefore admissible. And there's nothing that is substantially more prejudicial about that information than probative. The portion after that, where after Mr. Stillwell is asserting that people envy him, and he starts talking about the guy that just got beaten up in the jail. Defendant Stillwell asserts that he's a blood, he ain't real right. He's acknowledging his awareness and his use of the terminology, he's not real right. He's not a real blood. He's supposed to be a blood. And I believe that the female asks him, does he know his oath? If that's not what he's saying, that's what I heard, and that would make that relevant to us. Mr. Stillwell then starts talking about, I believe, the way that law enforcement spoke to him, or how he was approached about talking, and how law enforcement, how other people were approached about
This is
talking
so
about their
vague,
case.
and it's annoying.
That colloquy is relevant. He's particularly as well for what he's not saying, as well as for the fact that he's aware that he is being asked to talk about things and how he's dealing with that. So our position is that it's not substantially more probative. There's nothing in that span of the call that is substantially more prejudicial than probative.
Okay. Honestly, that was the way I took that last part about getting pushed up on the right way or the wrong way. My impression was he was talking about law enforcement as well, wanting to have him say whatever he was going to say about the case. So I think that would be relevant. And I mean, if you can shed more light on it, go ahead. But that appears to be the topic of it.
I mean, the only thing I can do is ask everyone to listen to it again. I mean, we might just have a difference of opinion, but when I've listened to these calls, I'm of the belief that, I mean, all this has been discussed in the previous calls, but he's talking about people pushing up on him, which
In the jail.
in the jail.
Is that what you think it
Yes,
means?
I mean, that's what I believe it to be. And so I understand that Your Honor has already ruled one call in. I think at this point it's becoming cumulative. I didn't hear the thing about the oath, but to the extent that the young lady is talking about Shannon needs to know his oath, which I didn't hear, but to the extent that that was said, I mean, that was said in the previous call. So to me, the talk about Woody, I believe it's fair and accurate to say that it appears that Shannon's talking about Woody when he says he envies me, he always envied me, but that ends at 13:30. So that's my stance, is any relevance, which I know that the state's arguing it's relevant and it passes the 403 test, ends at 13:30.
All right. Well, can you start from 13:30 again?
Yes.
I got you.
I know you were laughing.
I was mad. I was like, eat that baby.
Shannon, shit. Oh. What you fighting for?
Your blood, he ain't real right.
He what?
He ain't real right, public blood.
He what?
He ain't real right.
relevant and not excludable under 403. So I'm going to allow this over objection.
Yeah, of course.
The next call is November 18th, 20.
Oh, wow. I have 140 streams and videos about this case. Do I have any summary ones? Let me just check here. Sorry. I mean, if people want to just, okay, what is going on here? I would suggest day one opening statements. And I have that. See if I can post the link here. Because the difference in between the state's opening statement and the defense opening statement and that then what actually happened in trial is mind-blowing. Not just because Miss Love quoted Rudyard Kipling. Now, he wrote The Jungle Book and some other books. I like The Jungle Book, but I would never quote The Jungle Book when talking about underprivileged black youth. I would be so cancelled. I would be so immensely cancelled if I started to quote out of The Jungle Book to describe young black men. Imagine the things that could have been done to me if I went to Atlanta and started talking about inner city youth, underprivileged black men, quoting The Jungle Book. Miss Love quoted The Jungle Book. Book is excellent. The author, Rudyard Kipling, one of the biggest racists who has ever walked this earth. Hands down, one of the absolute... Imagine me, the whitest guy alive, quoting one of the most racist person who has ever walked this earth about young black men. Yeah, that's not... No. I mean, I'm not that... I mean, I don't claim to be an overly intelligent person, but that would be self-ending stupid. All right. But yeah, so day one opening statements and then compare to just a random days of testimony. That is what I should suggest. All right, let's continue.
15 at 17:30, timestamp 10:45 to 11:21.
Yeah.
Mother called that you got. Shit, man. At the back, I'm talking about all along. Yeah, so you fed him and you want a twin in? Yeah, twin in him.
All right, skipping the call.
November 19, 2015 at 19:35. And this one will be played from 1 minute and 27 seconds to 9 minutes and 20 seconds.
Okay. skip through that one.
Him.
Instead of 9/20.
All right.
So, Your Honor, from what I hear, Mr. Stillwell is calling someone who lied on him a rat, and that's something I will deal with. I don't have any problem with that.
All right.
As far as 640, we have a complicated situation. I don't know how the state is going to try to play this, but there's a way to try to play this that would likely mislead the jury. I would hope that the state wouldn't do that. In 640, factually, Your Honor, Mr. Stillwell had been charged with this murder with Mr. Copeland and others. Mr. Stillwell brings up yak and doo-wop. The reality, as people in the criminal justice system and are familiar with Fulton County know, that you have a prelim. And at the prelim, yak and doo-wop came up in the statement, in the testimony about what other people were saying. So it is completely logical that he brought up yak and doo-wop there. However, if the state wanted to mislead the jury and not tell them about a prelim and not tell them about how yak and doo-wop were brought up in the prelim, they could try to twist this into something like Shannon's bringing up people that weren't even charged. But I mean, we're gonna, if we need to have 3 days educating the jury about how the criminal process works in Fulton County and preliminary hearings and all the rest to really complicate matters, to explain that to them, I guess we can. I prefer not to. But he's just recounting what was said at the prelim. So I would object. It seems like a simpler solution is just to take out where he's talking about yak and doo-wop at that time.
Judge, June 10th, I believe we are midway, if not further along in the Copeland interview. I believe that it's Mr. Copeland who is bringing up these names that Mr. Shard is talking about. I don't hear Mr. Stillwell talk about a preliminary hearing. I hear him say they're bringing up.
So this conversation is November 19th of 2015, right?
Yes.
All right. What you said something about June 10th. What are you?
Just that prior to that time that Mr. Copeland was the one who was bringing up these names.
Did anybody have a prelim
They all did.
on a couple of days before?
They did. And Mr. Sledge, as the state is very aware, in these other phone calls, there's discussion about the prelim, and Mr. Sledge's case was dismissed for lack of probable cause at the prelim, and the testimony or the statements made by other witnesses, including Mr. Copeland, was discussed at the prelim.
Okay. Well, I mean, I don't know that you can tell from here what he's saying is somebody else let these names out. Somebody else is throwing these names about, and your client seems concerned about that. And that's relevant. I don't know that it's relevant how he heard that was going on, but it doesn't sound like, I mean, it sounds like as long as they play the whole thing, he's saying, whoever this is throwing these names around. It doesn't sound like he comes up with that on his own. He's talking about this other person is saying these names.
Right. But here's the dilemma. It's an unindicted case at this time. He doesn't have discovery. And what I am concerned of is the state saying, oh, wow, probably in closing when I don't have a chance to respond anymore. Oh, wow, what a coincidence. Shannon Stillwell in that jail call is saying yak and doo-wop, even though they weren't charged at this time. That just proves everything. And the reality is those names were thrown around in the prelim days before.
All right. Well, they may have been thrown around in the prelim. They may have been thrown around in interviews. Apparently, it's a whole lot of gossip that goes through the jail. But the state needs to make sure that they don't
We couldn't do that.
mislead the jury during the evidence or in closing with something that not to be true.
We agree with that.
Okay. All right. So it doesn't sound like there's an objection. It just sounds like there's some caution about how this might be used. And I'm telling the state right now, you better not use it in a way is not supported.
We agree and understand.
Okay.
I could bet money that the prosecution will use this in a very bad way. Why do I say that? Because that's what they do all the time. All the time. Yeah, exactly, Teresa tries. So why play it to even risk the prosecution doing something foul?
My notes are clear. To recap, November.
I'm going to make Nita Tickles Shved. Is that correct? I have no clue. If I butchered your name, my apologies. I'm trying. But thank you. Welcome. Thank you for being here.
November 19th, the state is planning on playing 1:27 to approximately what time?
That was, Your Honor, 1:27
Oh,
to
tickles.
9:05.
9:05 minus
Nita Tickles.
reference
Ah,
to
The
bond and
bond,
criminal
yeah.
history and minus reference to wanting to slap an attorney,
That is correct.
who is not me.
Who, once again, is not you. All right.
The next call we'll play is November 23rd, 2015 at 16:08 p.m. from 8 minutes and 50 seconds till 16 minutes.
remember, folks, most of these are third-party hearsay. Sometimes a defendant is there, sometimes they're not. Yeah. Jumping ahead, because I am really not interested in the calls by themselves, but I am interested in the argument.
But I just really be shaking that shit.
That's what I'm saying. That shit be crazy. You be with a nigga 388, 188, whatever. 2 years, 5 years, and situation pop up and you're like, boy, he did. That be crazy. That's what I'm talking about.
Exactly.
The longest trial in US history, if I remember correctly, because I actually looked this up, was a case where the trial started somewhere in the 1910s, and it wasn't resolved until, I think 7 or 8 years it took them. But it was like a 5-year gap in the middle of it. Maybe because of the First World War or something like that. There was in the 1910s, and then some 8 years later it was resolved, but I do believe it was because of the World War I got in the way. Fruit Company, yeah. I don't remember. All I remember is it was on that year and stuff like that. But if you're talking about continuous trial days, well, the OJ is still longer than this one, but they are catching up, because remember, the prosecution's case in chief isn't even over yet. It is currently the longest trial in Georgia history. That much I know.
The nigga sit right there.
Thank you for using Securus. Goodbye.
I have no clue.
That's all for that call.
The longest trial I know of, but now we are going to Sweden, who has a different system. The person was in jail for 5 years before trial. And then the trial took maybe a month, and he was acquitted. But he spent 5 years in jail. 5 years in jail. So yeah, I cannot for the life of me say that our system over here is better, because it does sometimes, in exceptional cases, have people incarcerated for years before trial even begins.
Okay. Oh, wait.
On this call, there is extensive discussion about the issues Mr. Stillwell is facing hiring an attorney. I don't believe that that should be relevant. That's A. Regarding 1315, approximately at 1315, as I hear it, Mr. Stillwell is saying that Mr. Sledge told him that someone, and I think it was Lil D, said that he being Sledge was with him during a separate incident, which is, I believe to be the 428 incident shooting up houses. But in that segment that starts at approximately 1315, we have Mr. Stillwell passing on hearsay from Sledge about what Lil D supposedly said about Sledge in a, I'm not going to say non-related because it is on the indictment, but non-related to, it seems, the Donovan Thomas case.
Oh, I wasn't muted.
Situation. So that seems to be hearsay wrapped into a statement by my client. I don't believe that that should be admissible. And that's 1315. I don't have an end time. And then, quite frankly, after 1315, there seems to be a lot of kind of laughing and giggling that don't really have a lot of relevance to anything that I can ascertain.
Okay. So we got the discussion of the lawyer, the kind of hearsay from what Lil D said, and then the sort of end of the call. Sorry. Yeah, I just was summarizing what Mr. Sharp said. Okay.
What I heard in the court summary was the discussion of the lawyer, the summary of what Rudy said, and then the end of the call.
Right.
Okay. So in terms of the lawyer, as I said earlier, with respect to what the lawyer is saying about sentencing and all that.
Yeah, no, I know. We all know that's out before that.
But the part about defendant William, or Thug, as he puts it in the call, getting him a lawyer, I'll point the court's attention to over at number 97, wherein there is in the lyric of the song Just How It Is, the assertion gave the lawyer close to $2 million. He handles all the killings. We don't speak about shit on wax. It's all my business. We know how to kill the biggest cats of all kittens. And so our assertion would be, considering that Mr. Stillwell is discussing a lawyer who has been sent down there to talk to him by defendant Williams, and that he wants all his money up front, that could be, their inference could be made by a jury reasonably assessing the evidence that this is part of the proof for that particular overt act. It's not just in a vacuum discussion or negotiation with the lawyer. It's who's providing him the lawyer, what it is the lawyer is asserting that he wants.
Okay.
He wasn't provided a lawyer.
That's our basis for the relevance of the portion about the lawyer.
All right. I agree that's relevant, and I don't see a 403 issue with that. All right. What about the kind of hearsay reporting that Lil D says or kind of admits to have done it, and that Montauk was with him for one of these other?
It goes to show the level of awareness within the jail by defendant Stillwell of what other people were saying, and the fact that Lil D swore to God the police lied on him. It would help explain. I don't know what, and I think he's actually talking about Garlington, but it was Quindaria Zachary was one of the people that told that he and Mr. Sledge committed the April the 28th shooting on Adele and Drew Drive. And to the extent that either one of YSL members, Shannon Stillwell himself or anyone else, confronted
the Gaines case. Oh, court case. Yeah, that one. Yeah, but that is the entirety from lower court up to Supreme Court. That took over 50 years. And she died in 1885. So that is, yeah. So, yeah, from start to absolute finish as a decision in the US Supreme Court, yes, 57 years. But I think when we are talking about trials, we are making the argument about one trial. Because if we are going by decisions in higher courts, you do have, I think the longest time somebody has served prison time between conviction to being exonerated is almost 60 years. So there are a few of those. But when we are talking about longest trial, we are probably only talking about the proceedings we are in, like that. But thank you. That the Gaines case is actually really, really interesting. It is Myra Clark Gaines. She was the plaintiff in the longest running lawsuit in the history of the United States court system from 1834 to 1891. And she died in 1885. So the last 6 years, she wasn't alive. But thank you, Ted. Thank you. If you have the time, read that wiki page about her. Myra Clark Gaines. It's really interesting. Maybe I should do one of these read-through thingies about that case when I get the time somewhere in the future. But we are here for the young thug.
Him about telling the fact that he's asserting, I don't know what the police are talking about. They're lying. It speaks to this culture of you're not supposed to snitch, and the fact that they know that they're snitching. If they are changing stories, it would help the jury understand why stories get changed when witnesses take the stand, in particular the witnesses that we expect will be called, and frankly, one of the witnesses that's already on the stand now.
All right.
I believe that what Ms. Love is using to defend that portion is not in the portion that I'm seeking to omit. There's a discussion about Lil D told, and then he swore to Sledge that he didn't tell, and the police are lying. Okay, that's not what I'm talking about. At 1315, there's a discussion about Sledge saying that Lil D told on the 4/28/15 shooting, told on Sledge. It seems to me that
that's a co-conspirator statement. Sledge telling him, or if he's discussing
Thank you,
that
Travis.
Antonio Sledge is bemoaning the fact that Lil D told, he's apprising him of the fact that someone's snitching on a member of YSL.
well, we just changed the verb. He was bemoaning, and now he's apprising. The bottom line is he was bemoaning, it sounds like to me. He was bemoaning the fact that Lil D told on him on something that Mr. Stillwell was not charged with. So I don't know how that's relevant.
The fact that the information is getting passed along through members of the gang to other members of the gang
Jesus
is what
Christ, come
we
on.
believe is the most relevant part of it.
Mr.
And it explains, it's defendant Stillwell's assertion, his asserted knowledge, and it explains people's behavior when they get in the courtroom and tell God's honest truth.
Okay. Mr. Stillwell in his calls makes it clear that he's being transported to all his court dates with Mr. Sledge. That's not a mystery. The state puts him in the same bus, and apparently, I'm not denying that Mr. Sledge would have probably talked about things going on in his life to Mr. Stillwell, but this is a completely unrelated incident that Mr. Stillwell's not charged with. So,
Well, he sort of is based on the RICO count. I mean, I don't know that he knew he was going to get charged with RICO at the time, but
let me just add this, just for the court's understanding where I'm coming from. Mr.
okay, do not come back in here with that if that's going to go off again.
Mr. Stillwell, Mr. Sledge and Mr. Garlington pled guilty to this
Right.
incident. So,
Okay, and
no, Mr. Sledge and Mr. Zachary, I should have said, pled guilty, and Mr. Garlington.
right. And so how is it a co-conspirator statement, I guess, is, I think, the gist of, are you just saying relevance, or are you saying something beyond that?
The state is always saying it's in furtherance of the conspiracy, and I'm maybe I'm just failing to grasp how Mr. Sledge bemoaning about that someone's telling on him is in furtherance of any
Okay,
conspiracy.
so yeah, that's the issue on the floor.
So it's a statement of Shannon Stillwell about what Mr. Sledge has said, and it's showing Mr. Stillwell's awareness of what is happening with other members of YSL and these charges that each of them are facing.
Right.
This is the problem, folks. This is how Georgia lawmakers wanted. When they wrote the Georgia RICO Act, they wanted it to be broad and vague. And that is the only reason why Ms. Love's assertions to the court sometimes work. Because the lawmakers want it to be as easy as possible to convict people. Yes. So it all comes down to politics. Oh, look at us, our mighty, mighty politician. We promise we will strike down on crimes. And while they claim that, people go, ooh, throw panties. And then they make stupid laws. Like the Georgia RICO.
How is Sledges having told him that in furtherance of the conspiracy?
Well, letting one gang member know that another is telling on them is letting that other know and to be aware and wary of, as that other also told on Shannon. Let them know and to be aware and wary of that person ratting and telling the truth on the gang itself. It's apprising them of something that may harm them.
Okay. All right. I'm going to let it in under the co-conspirator exception. All right. And then there's the part that's sort of the end. Is there anything relevant in that part?
Not beyond the part where he's not at the very end. There's a little bit, and when the court says the end, I'd have to go back. I think I played.
Well, I guess everything after that little part is about the, what Sledge says about Lil D saying. After that, is there anything? And there may be.
Let's see. Hang on one second.
Sure.
I'm checking the notes. This is right here. About a minute before the end. Replay it.
I would ask if we could start at 14 minutes, because I believe there may be something.
When he left the club, so they like.
Play. It entails a couple of things. They're talking about Woody telling. They're talking about the.
We are getting dangerously close to Judge Glanville type of, I'll allow it. Now, we are not there yet, because she actually forces the prosecution to streamline. Now, there are two things about that. First of all, it gets us to the defense case in chief faster, and we get closer to an actual decision from the jury as faster. It also, in appellate issue, the difference between how Judge Glanville conducted himself and how Judge Whittaker conducts herself as a judge, that difference in itself is an appellate issue. Now, do I believe that Judge Glanville eventually would have forked up even more Yes. He might actually now the ex parte and everything around it should have rendered this trial dismissed with prejudice, but apparently it doesn't. I mean, we are so far over the line of judicial misconduct, it is absurd. Honestly, it's so absurd. But had George Glanville been allowed to continue, he would have forked up even harder. But here we are with a new judge.
So in saying guns up, and I'm saying guns stay up, we believe that that's a reference to Peter Rolak, sex, money, murder, bloods. So for that portion, we believe it'll be relevant.
I mean, those seem relevant. That
Yeah. Hey.
Are you streaming?
Yeah.
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 Told me to come up here and bother you.
Yeah, of course it did. Yeah, I am actually live right now.
Oh, okay.
Yeah.
Nice. All right, well, I'll leave you to it.
Yeah, okay. See you. Bye. Oh, Dave is such an asshole. He sent his son up here to bother me. Oh, I'm going to get you, Dave. I'm going to get you so hard.
other part in between, you can redact out.
Yeah, I don't know what the state's talking about with the guns way up thing, but I would ask at the last minute be played.
I'm sorry, you would or you would not?
I would.
Okay. Got it. I think they will. Right?
Yes.
Okay.
That's what we were saying. From 15 minutes and 15 seconds.
Okay.
To the end.
Okay.
We were playing that.
All right, let's move on to the next part. Or the next part.
Yeah, yes, Travis. This entirety started with Fanny Willis, Phony Willis, Phony Willis, whatever she pronounces it. She was representing YSL Mondo a few years ago. And I believe that everything she learned about the YSL and everything happening here, she learned from him under the client attorney privilege. But she still used all that information to make this trial happen. Hi, Dave. Yeah, so it's my theory. This entire RICO trial only happened because she knows stuff through YSL Mondo. She's using attorney-client privilege information. For me, it's apparent. Now, proving it is another thing. Hopefully, YSL Mondo comes on the stand for the defense and says exactly that. That is my hope.
Next call is December 4th, 2015 at 15:48, starting at about 11:57, but we'll start at 11:30 to be safe to give context.
Yeah, we can skip through this phone call as well.
Thank you. The next call is the last call that we have. It is the November.
Thank you for using.
This just seems like a recap of the whole Montana situation. They're just rehashing the jail call that the state's already going to be playing. If Your Honor is going to allow this in over my relevance and cumulative objection, there is a point where Mr. Stillwell says something to the effect of, I knew him from when we were down the road. That is common parlance and for being in prison. And so that reflects on my client's character.
Okay.
We agree that would come out, the part about prison or being down the road. And with respect to the remaining portion of the call, it's the reference to throwing up YSL in the context of that similar call as the other one. That makes it different and a little bit
I
more.
mean, there's a specific mention of YSL, so I don't think that is cumulative based on that. So I'll admit that.
And Judge, there was one more call. I said this was the last one, but there was one that we passed over.
Okay.
It is the November 18th, 2015 call at 1843. I don't believe that we played it. I think we referenced it. Okay.
We dated that yet.
Okay.
Hi, Rhonda. Good to see you. I thought they said this was the last one 2 calls ago. Are they having a break? Yep. All right. Let's see what happens.
Several folders. We appear to have 2 for Mr. Arnold, Garlington, Kendricks, other items, and then some, I don't know, pictures and things. So can we move through them methodically? There's a recording in Mr. Arnold's. Is that what we've already gone over? Is there anything we need to take up that we haven't already dealt with on that? Okay.
Not with that I.
Okay. How about in Mr. Garlington's folder? Is that his statement?
Jesus.
Your Honor, the item in the Garlington folder is a jail call.
Okay.
And to make sure, at this time, I don't believe that jail call will be able to come in.
Okay, so state does not intend to use that. All right. And now I've lost my place. Well, what was next? Because I have no idea where I was just looking at what has gone to on this computer.
So I think the next folder, Your Honor, is the folder that says Diamante Kendricks.
Okay.
And there's 3 jail calls in that folder, Your Honor.
Can you give me a minute, Your Honor, because the Wi-Fi.
Maybe that's what happened to me too. It just bit poof.
What? The prosecution forgot to send the folders with the information they sent out? I don't know. I didn't listen to this part because I was out watching boats.
Ms. Hilton?
Yes.
So just so I'm clear, we're talking about the other folders in the sprinkle folder that have other people's names, correct?
Yes.
Can you give me a minute, Your Honor, because I can't get the courtroom Wi-Fi.
Okay, and you know what? I think we've maybe got access to some sort of a Wi-Fi router or booster that Ms. Persfield's going to go try to get right now, so that, because I'm not really sure why Fulton County can't provide stable Wi-Fi in the courthouse, but it's a continual problem. So let's see if we can get a router or whatever it is. Not very tech savvy, so I don't know what the right term is, but
I have not sailed yet. Sailing is tomorrow, where we are going to that lake that is due east of Detroit, and Dave is going to take me sailing. So just so you know, I'm having a full day tomorrow with stuff I'm going to do. I'm not entirely sure when we get back from sailing and everything that I have the energy to stream. Friday, I will. Somehow I will find the time. If not, as you know, it's Friday panel show. And hopefully I can get Phil here. So with the usual suspects that I always invite, and we will have an absolute excellent Friday panel show. During that Friday panel show, at least an hour in or so, let's just say I'm going to test. For you who don't know, I bought instead of buying, the mug from each state and stuff, I bought a shot glass from each state. And there may or may not be a wheel of regrets on Friday. Is court out the next 2 days? No. I thought they were having... I missed that in that case. They don't... Yeah. Well, if they don't have court the next 2 days, things will be much easier. Then I will record an update on the Donna Adelson case. I will record an update on the Tate brothers case in Romania. I will have an update on the Delphi. Lots of updates about other cases I follow. But that will probably be 10 to 15 minute videos. And then Friday, it's Friday panel show. Okay. Yeah, okay, there is court tomorrow. Okay. Okay, just 3 days next week. We will see. What I'm saying is tomorrow I have a full day with we're visiting the bourbon distillery tomorrow. That's it. Somehow we are visiting it before lunch, but I'm on vacation. And then we are going sailing, because why not go sailing after you visit a bourbon distillery? Oh yeah, Wheel of Regrets in a Treehouse should be very entertaining. Yes, it will. I mean, as long as I'm here, I'm safe. Problem is if I need to go outside, because it's a 7 feet drop, and I need to not drop. Am my knees better? Yes, my knees are better. My doctor back home in Sweden talked to a medical facility here outside of Atlanta, and I got an injection in my knee. I have no idea what's in it. It might be horse tranquilizer, fast concrete, and mustard, for what I know. But knee is actually working. So, but they did tell me that will hold it together until you get home. So there is slight chance I will regret it once I get home. But until then, I am on vacation. Did we make it to Mackinac Islands? No. Yes, we are sailing on Lake St. Clair. Yes, tomorrow. And I will be live streaming that on my road trip channel, which is N.Starow Road Trip. And you will find it. So, yeah. Yeah. It will be amazing. It will be so much fun. Yeah. So, nerve blockers. Yeah, probably. But I will... Once I get home, I will see my medical provider, and we will see what we can do about it. Folks, take care of your knees, especially if you're doing sports. I did a few sports when I was younger, and that is probably what I'm paying for now. So take care of your knees, folks.
Something to help us. Thank you. All right. Now, there are two different Arnold folders. Do they contain two different things?
Yes, Your Honor.
Okay.
So one folder is the interview that we talked about a couple of days ago.
Right. Okay.
And then the other interview are 4 jail calls.
Okay. All
That will more than likely he is expected to testify, Your Honor, and so we would use these primarily for impeachment purposes.
Okay. All right, so we probably don't need to take those up right now.
Well, all of it, I guess, the four jail calls as well as the interview would only come in for impeachment purposes.
Okay. I'm not telling anybody to not do sports. On the contrary, if you play some kind of sport, you have the baseline of conditioning and stuff like that. What I'm saying is take care of your knees. If you hurt your knees, be sure to do all the rehab training. Not just until it stops hurting, do all the rehab training. I did not do all the rehab training after I injured my knees, and here I am stumbling around. On a good day, I use a cane. On bad days, I use the two crutches thingy. That's not fun. That's not fun at all.
All right, what's in the other items folder?
Thank you, Rhonda, for subscribing to my YouTube travel channel. Thank you.
It looks to be a Justin Cobb. It looks like a social media posting. It is a social media posting. Justin Cobb. So I'm not sure if you're on. You can't open it. I think.
I could open that, or I can see a little thumbnail of that one. Is that something the state's
How
gonna be
about
using?
that?
Could you put it
New
up on
items from the prosecution.
Zoom maybe? I don't know. Is it working for y'all?
As of right now, yes, Your Honor.
Okay.
I wonder what these things are.
I'm not sure if you have access, Your Honor, to let me in the Zoom room.
Is it like exclude people once Wi-Fi goes out or something?
Or sometime at lunch, it'll kick me out at lunchtime.
Don't know why. Okay.
That might be purposeful.
So, Judge, this is on the screen. If you have, can you see it?
Yes.
So that is the posting that is in the other items folder in
Right.
Mr. Sprinkle's folder, and the purpose of it primarily is to show the phone number that Mr. Cobb uses at that time.
Okay. And any objection to that?
So, and maybe I need a bit more clarification. I understand it's a posting ostensibly by Mr. I don't know if it's by Mr. Cobb or not. And if they're indicating that he is the one who's posting that phone number, and how if there's information to verify that, separate and apart from this posting.
We would be having the person who found the post and who can talk about what they saw in the post, in the social media pages that they were looking in, to provide a foundation for it, like we would any other social media posting. Whether the jury believed that we have that right would be a matter for, I guess, argument. But we believe that based on what we were able to find, that this is Mr. Cobb's phone number. I think Mike Sprinkle is the one that actually found that posting. And
during pre-trial Daubert hearings, we heard from former ADA Sprinkle. Of what I remember, he got information from investigators, from this, from that. He did some double checking. I do not believe he testified anything under the Daubert hearing standard that he actually did some of this himself. If he did, yeah, this would be interesting. But from my point of view, Mr. Sprinkle, or former ADA Sprinkle, twice recommending to dismiss the charges is good for the defense. If you drink or eat junk occasionally, just try to give your body what it needs all the other time. Yeah, I only drink when I'm awake. I'm joking. I'm joking. I'm joking.
He's free underscore doo-wop. And he's responding to @Stunna Bumpkin with his phone number.
It's hearsay, Your Honor.
How is that not hearsay?
It's
because that is being offered for the truth of that being his phone number.
It's how we were able to.
Are you offering it to establish that that 678 number is the phone number that Justin Cobb / doo-wop was using at the time?
Yes, and we would not need to put that particular picture up as long as the witness is testifying how, he
The
came
witness
about it.
being Mr. Sprinkle?
88 Sprinkle. So he wouldn't just have that showing that it was his phone number. He would have other items of evidence to show that lead us to believe it is his
All
phone
right,
number.
what would those other items of evidence be?
I believe that we got his records, his phone records. So who the other
Well, then
calls.
That would be the way to show it then, through his phone records.
Right. So when he's doing the deep dive into who did what and how we are able to find out who is where, he starts out trying to get phone numbers for people. And this is one of the ways that
do we need to know that this is how he got it, or do we just need to know?
not necessarily, it's not one that at this time I think we would need to
Crying
put.
out
It's just
loud.
one that we
George,
had.
George, please stop helping the prosecution. They are a team. There are 3 people there. There are 2 more accessible, and they have an entire district attorney's office. If they fuck up, we're over 2 hours in, sorry. If they fuck things up and the defense does not, all you have to do is rule. You don't actually have to help the prosecution.
Okay, well, I would think that if there's some reason we need to hear from either Mr. Sprinkle or a phone records custodian, that this is the number for Justin Cobb.
And also, Ms. Hilton has reminded me, we had a number that was being used by another person who was being called. So these jail calls involved calls made to Javaris Bradford, and there were other numbers in his phone logs and in other co-defendants' phone logs. This was one of them. And again, it's going back to the fact that he, in an effort to find out who this number belonged to, I think that he, in searching social media, came upon this.
Well, it might be kind of cool that Mr. Sprinkle is good at finding nuggets in social media, but I don't know that that's relevant.
I know, Deirdre. Thank you. She does it for the defense too. Not even close. In my personal opinion, I might be wrong. If you think I am wrong, give me constructive criticism. I love constructive criticism because how else am I supposed to learn something when I'm wrong? So, yeah, but in my opinion, yes, she does it sometimes for the defense, but almost always for the prosecution. And in my opinion, the judge should listen to both parties here and then make a ruling and help no one.
To this trial. If this person's phone number is relevant to this trial, then establish that through the certified copy of his phone record showing that this is his number, okay?
Yes, Your Honor.
All right, Mr. Weinstein, were you able to do what you needed so that we can go over Mr. Kendrick's jail calls?
Yeah, I'm just using my phone because I can't get on the Wi-Fi here. It's a little funky, but
Okay.
I'm almost there.
Okay.
Give me a 5
Okay, no problem. All right, how about the other, like, what look like maybe individual pieces of evidence? There's, I don't know, the one that's labeled CKNQKS, whatever, that's a picture of somebody standing by a car. Is there any objection to this picture?
I think first we'd like to know from the state what it is they believe it purports to show, how it's relevant, and
Okay.
we can respond.
Your Honor, I believe this is a picture of Javor's Bradford, who is one of the individuals that we've alleged had a part in, as a party to a crime in the murder of Donovan Thomas. And specifically, Your Honor, we believe he's the driver of the Bonneville vehicle initially while they were at the Texaco gas station. And this is a picture of Mr. Bradford in front of what we believe to be that same Bonneville.
Okay. At a different time.
At a different time.
Okay. That seems relevant. All right, let's move on to the next. Color copy of sprinkle report. Y'all already used that.
Sprinkle
That's just
right.
giving that to them for, okay.
Right.
Very good. All right, then I guess we've got some more images, maybe?
Yes, Your Honor. The next few are again of Mr. Bradford at different times with that same Bonneville, just in case there was,
Okay. Is that what all four of those ones, next ones are?
except for IMG_03901, that is not.
Okay.
That one is the Infinity after it was sold at auction to the person,
Okay.
the next owner of it.
All right. And then is the last thing just a duplicate of that?
One's a distant shot and one's a close-up, Your Honor.
Okay. All right. Any objection to any of those?
I don't believe on behalf of the board.
All right.
No, Your Honor.
Okay.
And of course, for the record, Your Honor, we would take off the comments off of.
Thank you. It's working on mine, but Mr. Weinstein might need it. Okay. I think I'll just leave mine alone.
Okay. Doug.
Wi-Fi router passcode, just let Ms. Persfield know. I should try to email it to y'all, but in case you're not getting email.
Oh, hell yeah. Next week,
Okay.
Woody's cross-examination. Oh, it's, oh.
It's only the first call and Mr. Adams.
Okay, perfect.
Thank you, Judge. So we've got what appears to be three calls, jail calls here for Mr. Kendrick. The first one is a call that occurs on October the 4th, 2015. I'll just go ahead and set it up because it's an issue that's similar to the issue we dealt with Mr. Stillwell earlier. On that phone call at about the 2-minute and 50-second mark, there's a conversation between Mr. Kendrick and his significant other, someone named Tasha. His mom, yeah, she's significant to him. His mom, Tasha, is a conversation about an attorney. I believe if my recollection is correct, Mr. Kendrick says something to the effect of, I've got a lawyer or getting a lawyer. And Tasha says something to the effect of, Thug is working on an attorney for you. So number one, same objection as before. I don't believe it's particularly relevant. There has been an association shown between Mr. Kendrick and Mr. Williams. And so the fact that there is some discussion about whether or not Mr. Williams is going to assist him in getting an attorney, I don't think particularly proves anything in the case other than what the state intends to argue, obviously, as I've said before. And it bears noting that he does not get him an attorney. There's no evidence, there's no factually, it doesn't happen. He never maintains and gets an attorney for him. No attorney ever comes to see him at the behest of Mr. Williams. So I just don't think it's helpful to the jury in any form or fashion in regards to these charges.
All right. Ms. Hilton.
Your Honor, I think for the same reasons, Your Honor, it is our contention that when Mr. Kendrick is in jail following a fleeing and attempting elude, but when they are actually intending on going.
Nope. They are not done with Woody. There are still some of these jail calls interviews left on Monday. But I do believe if nothing extraordinary happens on Monday, we will hear cross-examination of Woody. Now, I will be back in Sweden by then. Oh, yeah, I know it's kind of sad. I kind of want to stay here, but I need to work and stuff like that. Now, for the sake of argument, let's say this channel blows up and goes to a level like Ian Runkle or Lon Lumber or Joe Niemeyer. Yeah, I would probably have the funds to at least make the attempt of joining you over here more permanently, or at least 6 months of the year. But we're not. I'm nowhere close that. So hit the thumbs up, do the subscribe, and when you have done all that and seen all that, consider being a member or something like that. Okay, let's continue with this trial.
Up to shoot up the opposition's home. They get stopped at a roadblock, but they were on their way to shoot at the opposition with a number of guns in the car. They then take the police on a high-speed chase, and he's subsequently arrested at that point in time. This call is important for that reason. Is the state's contention that when YSL members get in trouble, they reach out to Mr. Williams, and he provides attorneys. Whether or not the attorney comes or not, it is the fact that they believe he's going to provide them assistance. But what is more important in this call is what happens after that. So Ms. Tasha on the call says, Thug is going to work on getting you a lawyer. And Mr. Kendrick says to his mother, don't say his name, say bro. And what we have found consistently throughout this case, and we'll believe the evidence will continue to show, is there is an effort to conceal his identity, conceal Mr. Williams and who he is. And so they never reference him as Thug, oftentimes on jail calls, but it's bro, slime, or different other terminologies. And so that is also what is important with this call, Your Honor.
All right, thank you. I'm going to admit it over objection. And obviously, if y'all want to cross-examine the right person or put somebody on the stand to say he never got him a lawyer, that's up to y'all. All right, so was that the only of the jail calls?
Yes, sure.
Okay.
Of those three.
All right, thank you. So then I think we've taken care of everything in the sprinkle folder at this point.
Yes, believe so, Your Honor.
Great, okay. So then I think that also means we've taken care of everything in that whole entire 1 through 30 witnesses.
Yes.
Let's pat ourselves on the back. All right, we can move next to, don't we have this same thing for 31 through 60? We can move to that, or we can move to the wiretaps, or if there's something more pressing, y'all tell me. But we're not going to waste this time we have without the jury getting stuff done.
Generally, yeah.
31 through 60
Everybody
would be
talks
more
too much.
pressing before the wiretaps, Your Honor.
All right, let's all find that one. And is that a different Dropbox link? Can you remind us what the email would be for that one?
Yes, Your Honor.
Thank you.
Yes, Your Honor. The initial email was August 12th, Monday, August 12th.
Okay, thanks.
Yes, Your Honor.
Mr. Ryan has 31 through 35, and that's the one we're discussing with the state in the background.
Okay.
So we're still working on that.
Okay, so 31 through 35 set aside for now. Okay.
We're working on that.
All right, that's fine.
Okay, thank you.
Dropbox. Yeah. I would never allow sharing of discovery via Dropbox. Not ever. Why? Because the opposing party can see what you access at what point in time. So a skilled opposing party can track what you are looking for in order to get an advantage. Now, Dropbox, can you download everything from it? Yeah, but it's a hassle. It's a damn hassle, especially if you do as this prosecution does. Give it up really, really late. So no, I personally would not ever in my life agree to discovery via Dropbox. Let's just say that. If I was ordered to, I would still say no. If a judge wouldn't agree with me, I would still not do it. How can I say this with so much certainty? Because I already done it. It's just not secure. An opposing party can see what I'm accessing, and it's too much of a hassle. Download it on hard drives, give it to me. But never via Dropbox.
The next folder says 32 through 39. And there's only one witness in that folder, that's Officer Rogers. There's nothing in his folder, so we can move to the next folder.
Okay, I don't actually, I'm still waiting on the email, but
So am I.
Yeah, and Dropbox is extremely hackable. In my opinion, for legal reasons. Skip ahead.
everything now, but that's fine.
Everybody's waiting.
So we can start where it says counts 3 through 7, Your Honor, that folder, Acts 88 through 90, armed robbery, DeWan Maynard.
Oh, Jesus Christ. Oh, oopsie.
We are.
Okay,
Okay.
we're gonna just start with the Colin Russell folder that's in there. Ms. Hilton?
Yes, Your Honor.
Okay. And are these videos or just images?
There are videos, there's portion of surveillance video from the night of the armed robbery.
All right, and does anybody have objection to any of these 3 videos?
Portion.
Not for Mr. Huey, Your Honor, as it relates to these videos. I assume that it's going proper foundation will be laid. Give him a minute.
Anybody else?
Nothing on behalf of Mr. Williams.
All right.
Okay,
No,
let's watch
no,
this
okay.
on
And then
robbery
that last one looks
videos.
like it's maybe a cell phone.
See
Is
if
that
you
a
can
video
see
of
any
something
one
being
of the
shown on a cell
defendants.
phone, or what's that?
Yeah, let's look at that. Yes. It is a video, Your Honor.
It's a video from, we're alleging it comes from Mr. Huey's. It's someone taking a video of Mr. Huey's Instagram page.
Okay.
So we will lay the proper foundation to get it in.
Okay. Any objection? Assuming proper.
There's somebody taking a video of Mr. Huey's Instagram. Yeah. How on earth would that ever be manipulated to?
Foundation?
Understood.
Nope.
Objection, assuming proper foundation.
All right. Let's see what's in our next folder. Joel Hines.
There's nothing in his folder.
Oh, you already said that, didn't you? Folder number 38, Mr. Maynard. A lot of images. Everybody take a second and look at those and let me know if there's any objection to any of that.
Your Honor, with respect to
the second photograph on the first category on the first line of photographs at the top. The second photograph to the
It's like
right.
the hand and arm.
Yes, Your Honor.
Okay.
I'm not sure. The Instagram says Hunchoke, Hunchokae. Maybe the state can talk to us about foundation for that.
Yes, Your Honor, that is the picture of the victim in his hand. That's the picture that the victim provided to us to show that those are his items that were stolen from him during the armed robbery.
Okay. With that information, any objection?
So just so that I'm clear, my understanding, Your Honor, is that this is not the alleged victim's Instagram account. So I guess they'll have to deal with that if they call him.
I mean, not really, because what they're offering it for is to show that these were the victim's items that got stolen.
During the
So
armed
it
robbery,
doesn't really
yes.
matter where the picture came from. If he can say that's my arm and that was my ring and my bracelet.
We believe we have a different understanding of who the
Okay.
photograph that is, and we'll deal with that at trial.
Oh, you think that's not his arm?
Yes.
Is this victim going to testify?
Yes.
All right, well, we'll see what he testifies to. But it doesn't matter whose Instagram it came from. If he is going to testify that those are his items, I assume on his arm. I don't know. We'll see. Okay. All right. Any of the others?
If they pull
We have lots
Woody's,
of pictures of.
if they pull Woody's videos he made during all these months, when in the break, yeah, we're going to be here for a long time.
Guess a lot of jewelry got stolen, maybe.
Yeah.
Your Honor, I don't know. Obviously, the state has to present their case as they see fit with respect to all of these photographs. However, I do think a proper foundation would need to be laid for several of these photographs. So there may be some real-time objections as it relates to them, Judge.
Okay. Understood.
Okay.
All right. Other than that, then I guess we can move to the next folder. Mr. Jenkins, that's also empty. Okay, Officer Suk.
Yes.
Officer Suck?
So he's a crime scene tech.
He was the responding officer, Your Honor.
Responding
So we,
officer.
in order to cut down witnesses, we're going to bring in the crime
Alright.
scene photos from him.
All right. Any objection on any of that?
Subject to foundation.
All right. Then we've got Officer Francis. And what do we got there? Any objection on any of that?
It just appears to be more photographs of the same that were contained in another folder.
Yes, Your Honor. We put the items in places where either of those witnesses could introduce the
All right.
evidence.
All right. And then we've got Officer Greer.
Your Honor, I believe that this particular piece of evidence pertained to the motion in limine that we dealt with on yesterday that I believe was excluded, if I have that correct.
No.
No.
So Mr. Huey was arrested in 2020
Okay.
for this incident initially. And when he was arrested along with his girlfriend at the time, Miss Justice Woodard, and he gave a false name back when he was initially arrested on the armed robbery warrants. And so this folder deals with the officer who arrested him on those warrants in Fairburn, Georgia.
1 second, Judge.
All right, sure.
On the behalf of everybody who has watched this trial, every officer suck. Badum.
Mr. Huey has 2 armed robberies. This is the 2019 armed robbery. He was arrested in Fairburn and gave a false name on the 2019 armed robbery. I'm sorry.
Okay.
Judge,
Yes.
I do have a question for the state concerning the video that is in this particular folder. I don't believe this video pertains to Mr. Huey's arrest.
Oh.
It says female search.
There's 2
That's the-
videos, Your Honor. I think
Go ahead.
on the night of they both were searched. So I think it's just the body cam for both of.
Are you planning to show the search of the girlfriend?
No, Your Honor.
Okay. Is that the only one you had objection to?
This is not the girlfriend of Mr. Huey, according to this particular piece of evidence, that, in other words, this person that's being arrested is not associated with the arrest of Mr. Huey. That's our position.
The one that says female search or the other one?
That is correct, Judge.
Which one?
Oh. The one that says, that
Okay.
says female search.
All right, well, they don't plan to use it anyway.
Correct.
Okay.
Okay, so that's excluded.
All right.
Okay, thank you. 1 second here. All right.
So they tried to assert that the other female was Mr. Huey's girlfriend. No, it wasn't. Anybody can fake a video. And remember, these are, even from 2019, this is ages ago. That's 5 years ago.
So then we've got the AT&T records custodian. There gonna be any issues for that witness?
Just subject to foundation, Judge.
All right. And then we have Ms. Latner's again, and within her folder, we've got, I guess these are new things that we didn't look at in that first time around earlier today.
Yes, Your Honor. Okay. In order to try to reduce the amount of time the Latner's comes back, when she comes up at this particular time, we're going to try to enter in a few different CAD 911 calls.
All right, and has everybody looked at those? So if you've got any kind of objections like we had this morning, you can raise them. Although I've got to say, pretty much all of those things we went over this morning are kind of evidence 101 that you'll ought to be able to agree to. Not saying you want to, but any chance y'all might take this next group and see if there are actually some legitimate objections to those? Because we know it's all hearsay, but if we all...
I completely agree with Travis James here. Without metadata, it's out. Because there's no way of knowing if the thing that was recorded is the actual Instagram page or somebody pretending to be Mr. Huey's Instagram page.
Also know it's clearly covered by an exception. Maybe we should not make those objections.
Your Honor, the state's more than happy to meet with any defense counsel, or we can talk after court, or they can email me and we can, before tomorrow, at least speak with one another and hopefully come to some agreement.
I mean, that would be great if y'all could at least try. And certainly there were a couple where, okay, this is not sure. Is this something based on the CAD that an officer's saying, or is this what the caller's saying? Those are legitimate. But I mean, a caller calling 20 seconds after a shooting saying, here I am, and I just woke up to hear all these shots. That's coming in because there is a clear hearsay exception to that. So just see what y'all can do on that. And if you feel the need to go ahead and put forth the objection to each of them, then that's fine. We'll go through it. But, I know everybody's talking about how long this case has taken, and we could cut it a little bit shorter if we didn't do things like that. So I will let y'all talk about those over the evening, and we will circle back on Ms. Latin.
Yeah, a video of a video is not evidence. Thank you, Travis.
So does that cover everything that was in the counts 3 through 7 folder?
Yes, Your Honor.
All right.
No.
All right, where should we move to next?
We can go through count.
To this day, there has not been an argument regarding does the metadata match what's been shown to the jury.
14 through 23.
Okay. All right, does everybody have that one open?
Sure.
Okay, we'll just go in order.
1 second, 1 second.
Okay, no problem.
Just waiting for it to it's
Sure.
buffering.
His computer is doing a Miss Love. It's buffering.
There, Your Honor.
All right. Are y'all ready, Ms. Westmoreland? Are you still? Okay, so we are now looking at the counts 14 through 23 folder. All right, and we're moving to item 45 in there, or the one labeled 45. Okay. And that is an audio call between certain people.
Yes, Your Honor. So this is a jail call that we litigated last. 45 Tiana Stanley. 45 Tiana, Tianna, Stanley, Stanley.
Okay.
Your Honor, this is a jail call between the victim in this case, Gary Holloman, who is now deceased, a co-conspirator, Tinquarius Mender, and Tinquarius Mender's mother, Tiana Stanley. We did litigate this, I believe, in October of last year, and it was admitted based upon that litigation.
Okay. Anything else on that?
Your Honor, it was, just for the record, the court admitted it under the 807 residual hearsay exception,
Interesting.
and it was admitted over our objection, my objection. This was a jail call, and the deceased was having a came onto the call at the behest of the inmate and the inmate's mother, Ms. Stanley. And that person came onto the call, had a conversation on a recorded jail call. And our position was that there was no establishment that the deceased, Mr. Holloman, had a very close relationship with either Tiana Stanley or with the inmate. And we objected on that basis. We did not believe that a jail call was a trusted conversation, that it was done on a public recording that was subject to a public airing, and that there was no establishment by the government that there was this trusted, close relationship that is typically required in an 807 setting, and that and for those reasons, as the court is aware, 807 residual hearsay is like the Hail Mary of letting evidence in when there's no other recourse, no other way that it can come in, so forth and so on.
And it happens sometimes when people die. All right, is there an order that I can look at?
Yes, Your Honor.
So this has not come in to the trial itself at all yet, is that right?
It has not, and there is an order, Your Honor, and we can forward that to you.
And also, Your Honor, just from the standpoint of Mender, who's on this indictment as well.
Okay.
So we would argue that, well, it was admitted under the 807 exception to the hearsay. We obviously don't believe that it would be anything that would come in under any type of co-conspirator theory or anything of that nature as it relates to Mender, who is on the indictment. It's not furthering any conspiracy or anything of that nature. If the state were saying, hey, it should come in because Mender's a co-conspirator or something of that nature. So it only came in under the 807 basis.
All right, was that an argument that was made and addressed?
No, Your Honor, we addressed it solely under residual hearsay.
Okay, well, if y'all can, if you want to just let me know the date of the order, y'all gave me that binder full of motions and orders, so I can find it not during court time. I can do that this evening and let y'all know.
And I'll tell you, Your Honor, the order, because there were several things we argued during that hearing. There was a 911 call, there was a body cam video, and it was this jail call, Your Honor. And the court excluded the body cam video. And I believe the order primarily addresses the body cam video and not necessarily the 911 and the and the jail
How about
call.
that?
Do I then need to look at the transcript?
Yeah.
Okay. Do you know what date that was?
It was November, I think it was November 3rd, but I'll pull it up just so.
Okay. All right, well, we'll come back to that one.
Hey, Jack Matt, welcome to the show.
November 3rd of 23.
Yes, I printed the order for yesterday. So hold
on. Okay.
And they're searching for more stuff. Let's skip ahead.
The order was filed on November 16th
Okay.
of 2023.
All right. And do you know whether that transcript's been filed? I can always check with Miss, I'm blanking on her last name, Christina Weaver.
I don't see it.
Okay, it's fine. I'll just check with her. All right, so let's just move to the next folder, I guess.
Okay.
Yes, Your Honor, there's nothing else.
Nothing, okay. Sergeant Henderson?
Your Honor, Sergeant Henderson was the detective on this particular case with respect to these acts. And the court has excluded his participation with respect. He had two primary roles with respect to these particular acts. One was to do the photographic lineup. and
Right,
The other was to
can't
conduct
be
the
in,
interviews.
yeah.
So I think that subject to that ruling are in this particular folder are basically
All right,
photographs.
let me just ask the state, what all do you intend to use from this folder?
Yeah. Why don't you answer within 2 seconds?
Can't hear you.
The pictures are duplicative, Your Honor.
Okay.
We've put in here Mr. Huey's statement. I don't think at this time we're going to use it, but we did just place it in here as an abundance if we decide to. I don't think we're going to be using his statement. And
I
the
don't think
MP4
does not mean you're not going to
is,
try.
and it should not come up, but the MP4 is I guess on iPhones, I'm not an iPhone user. You can scroll the text messages and see all the text messages. And so the last MP4 were text messages between our victim in the case and the detective, because our victim lived out of town. And so he was communicating with the detective about the robbery and providing information to him via this chat. So potentially coming as impeachment, depending on what happens with my victim. If my victim says something inconsistent.
This is not the dead victim. This is
No,
a different victim.
Sorry, totally different victim. I apologize.
This is not Mr. Holloman. This is
Mr. Maynard. No, this is Mr. Maynard. So this
Maynard.
shouldn't be in this folder. This actually should have been in another folder.
All right. So, okay.
This video is from the 2019 armed robbery.
Okay. It's just in the wrong folder, but that victim is going to come testify and you might need to use the text as impeachment. Okay.
And I should also be clear, Sergeant Henderson, ironically, was the lead detective on both the 2019 armed robbery and the 2020 armed robbery.
All right. So is there anything in this folder that y'all intend to use? I mean, obviously that is just accidentally in there and you'll use it as to a different topic, but how about with regard to the, I guess, armed robbery of Holloman?
No, there's nothing in this folder that we intend to use.
All right. Thank you. All right, so then we've got Investigator Belknap. That folder's empty.
Yes, Your Honor, and I just realized when Mr. Huey was arrested for the October armed robbery initially, there were items found at Mr. Huey's apartment that belonged to an individual by the name of Chandler Durham. I do not see those photos in here, so I need to add them, but they're in discovery.
Might be in a different folder.
They have been served. I see the
Wrong
videos
folder,
in some
sure.
other folders, but I'll make sure that what we intend to bring in through Investigator Belknap is placed
All
in this
right,
folder.
and that was a search that was not, that
It was a search.
items can come in.
Yes, and Your Honor, it becomes relevant because in one of our acts, which is act number 102, we have alleged as an overact a text message between Mr. Williams and Mr. Huey, where Mr. Williams demands Mr. Huey to take his shit back, and his that he is talking about is Chandler Durham, and so all of that becomes relevant.
Okay.
So we'll I'm sure the court will anticipate certain objections at that time. Again, there are a lot of assumptions that are being made with respect to what it meant in the context of it, which I don't believe a detective is going to be able to, other than speculate, be able to know precisely. So we'll deal with it.
Okay.
And I don't believe Mr. Chandler Durham is on.
I'm just going to water the lilies outside this door for a minute. I'll keep playing this.
State's witness list, I don't believe.
He was on our original witness list, but in an effort to cut down on witnesses, he's not on the reduced witness list. He is not.
Okay. So I assume there'll be something that establishes that these were his items?
Yes, Your Honor. Yes, we have pictures of items similar to what was found. We have pictures of Chandler Durham with items that were found. Yes, and we also have the 911 call from the Chandler Durham armed robbery.
Where he says, these are the items that just got stolen from me?
He talks about being robbed. I don't know if he says it on the 911 call.
Well, I don't know if you might need to put him back on your list, because think about, what they're going to hold you to your proof on everything. So
Yes.
there's going to be an objection if you don't have a way to establish that the items found in the search of Mr. Huey's home are in fact the items that were stolen from Mr. Durham.
Yes, we're working, I think we had worked through it that we could get around it, but
Well, we'll see.
we're working through it.
Okay, I don't know. All right, Investigator Flores.
Your Honor, based on your ruling, the next two folders, based on your ruling yesterday regarding the fleeing and attempting to elude, 49 and 50, we don't have to look into.
Okay. And then Bernie, is this anything that's different from what we looked at before?
Yes, Your Honor, we had Mr.
This is his second, like, more recent work he did?
No.
No?
So Agent Bernie, for several of the cases, analyzed phone records.
Okay.
So he just analyzed Mr. Huey's phone records relating to the October 1st, 2020 armed robbery.
Okay. Any issues about anything in that folder? Mr. Matthews?
We're good. No objection.
Okay. Thank you.
Hey.
All right, so that takes us to the end of the 31 through 60 folder.
No, I think.
No, I'm sorry, looking at the wrong thing. What was that?
So the next one we have, Your Honor, is counts 27 through 29.
Right, that was within the 31 through 60, that was 14 through 23. Okay. So now counts.
Which motion are you talking about, Mizibo? I don't know which motion. If you could clarify that, I would be so appreciative. No, Ashley Jones, love has not been yeeted. Not yet. I mean, she should be, but we all have our wishful thinking.
What'd you say was
27 through 29.
okay? All right, we've got several items in the Smith folder. Anybody want to voice objection to any of those items?
Okay, not much from that.
I'm having a tough time seeing which video I'm talking about, but I do know from my review of the discovery regarding this act, there is a FaceTime live or some sort of live stream of Mr. Beebe smoking marijuana, talking, saying absurd things, and I don't believe Mr. Beebe's going to testify. So I would object to I don't know what the relevance is of that. I know what the relevance is if he was on trial. He's wearing a chain that allegedly belonged to quote unquote trap commander, whose government name escapes me for the moment, but he was the alleged victim of this armed robbery, and he was the person with the chain. But I think a still shot from that live stream could serve the state's needs in that respect.
All right.
We'll be looking at some of the items. So in this armed robbery, we've alleged that two of the co-conspirators, Durante Beebe and Christian Eppinger, steal, armed rob Mr.
I'm sorry, say those names again.
Durante, Derontae, last name Beebe, Bebe, and Christian Eppinger.
Okay. I just didn't hear who you said next.
They robbed Darius Smith in broad daylight at Cleveland Avenue Park. And some of the videos that we have are of Mr. Beebe and also sometimes Mr. Eppinger holding one of the items that they stole. And so these are some of the videos. We will go through and narrow down which of the videos that we will intend to use for.
Okay. All right. Well, let's, if y'all can do that tonight, and then we'll circle back on that tomorrow.
Ay, ay, ay.
Going back through this folder, I don't see it in here where Mr. Eppinger is essentially bragging about the armed robbery. I'm going to look for it again, and then I will make sure everyone gets that video as well.
She lost the video.
All right, and then next in this folder is the folder that is Adrian Ansart.
He's the custodian records for Instagram, and so
Okay.
it's just an Instagram return to his folder.
And then we've got Sergeant Pierre or Jean-Pierre.
Yes, Your Honor, he is the lead detective.
Okay. Assume that. So there, I see photographs. Would those be like crime scene-ish things?
Yes, Your Honor.
Within social media, is there anything we need to look at within that? Anything objectionable?
That will be some of the stuff we're going to reduce down tonight.
Okay,
Your
all
Honor.
right, we'll come back to that also. All right, and then the lineup ID, that I guess is there gonna be a victim to testify to that, or?
Yes, the victim will be present, Your Honor.
All right, then those ought to have already been dealt with if there were objections to them. Okay.
44 through 46,
Okay.
which is the last set.
All right, we've got Deputy Timothy Brown.
And Your Honor, this is the possession of a weapon and cell phone of Mr. Huey and Mr. Mender, Your Honor. And so in here is just the body cam video of that search of that cell. And then we also have the jail records showing that both Mr. Huey and Mr. Mender were in the same cell together.
Who's the second name again?
Mender,
Okay.
Mender.
Mender, all right. Any objections? All right. And then Vivarito.
Yes, Your Honor, that should primarily be the phone dumps or cell phone extractions for Mr. Huey.
Okay.
And then there is also a video visit with Mr. Huey, Mr. Williams, and Mr. Mender. I see two of them, Your Honor, so I want to make sure there's a third one that was, no, I think all three are there. So there's the one of two,
Okay.
two of two, then there's the third one.
Okay.
And then we have some screenshots, but there might be more screenshots that we'll provide.
All right, and then there appears to be another PowerPoint. Y'all don't intend to use that, do you?
No, Your Honor, this was a PowerPoint that was used for grand jury, but
Okay.
it's something that we serve.
All right.
So they made a shit PowerPoint to the grand jury. That's good to know.
And then I don't know what that last thing is in there. It's not a folder. It says iPhone 11 Pro Max.
I believe, Your Honor, that is the cell phone dump just in two places.
Okay.
I just want to confirm.
All right. So does that carry us through that whole, through witness number 60, or do I need to go back and?
It does, Your
Okay.
Honor. Some of our numbers are a little off just because we have a few different lists, but this is all the 60.
Okay.
And then we intend to provide the last group of individuals to the end, the last witnesses to the end on Monday, Your Honor.
Was that the deadline I gave you? Or did I give you a deadline?
I don't know if we gave us a deadline for the last group, but we were doing it on Monday, so we just figured
Okay,
it's time for
That's
another
fine.
Monday.
all right, so that'll be 61-ish through the end of
Yes.
your witness list.
Yes, Your Honor.
All right, so then that would leave us tomorrow looking at these couple of things we set aside for today. And then, I mean, at some point we need to get to the wiretap stuff. So tomorrow then would be the day to do that because we have a free day tomorrow. We need to utilize it. Okay, so we'll break early today, but with the understanding that everybody needs to be ready to tackle the whatever is within the wiretap evidence tomorrow, as well as we'll circle back on the CAD reports after y'all have gotten a chance to get together, and then on the couple of things from that we just discussed that you might be able to narrow down. All right, anything anybody needs to bring up, put on the record before we adjourn for the day?
I can't think of anything from the state, Your Honor.
Okay,
Nothing on behalf of Mr. Williams.
all right. Yes,
All
yes,
right.
there is.
Are we
And I don't
getting-
know if Mr. Adams can do this
we're
or read away
getting
from
close
Mr.
to the end.
Steele. We
I thought
did,
there was more.
Mr. Steele did provide to us the Dropbox link with some reciprocal discovery.
Mhm.
We know that there's some jail calls. There are a number of jail calls that Mr. Steele gave to us. If he could just narrow down which jail calls he intends to use. I believe this is with Mr. Copeland, so we can just know if we have any objections to
Okay.
it,
I'm,
objections to it, but just the jail calls.
I'm already at 1.25 speed, but we are really, really close to the actual end of today. So I don't need to.
We'll go ahead and reach out. I know Ms. Steele was working on that today.
Okay, well, great. Hopefully he can get that to the state by the end of the day.
I'll relay that.
Okay. Because obviously Copeland's cross is hopefully coming up before too much longer.
It's on the horizon, Your Honor.
So, yeah, that may be the first thing we need to take up.
Yeah, Miss Hilton, seriously, you claimed to the judge to her face you would be done by Friday, last Friday. Now when she's saying, oh, it's in the horizon, it's not going to happen Monday. Maybe Tuesday.
Tomorrow.
Can I inquire, Ms. Hilton? I know when we left off with Mr. Copeland last week, we were almost done, I think.
I mean, yeah, sounds like we've got a little bit more of that video still to get through, since we didn't really get anything done Friday afternoon because
A
of
jail
tech
call.
issues, but
A jail call, I think, if I remember correctly, Ms. Hilton.
Yes, the goal
mhm.
will be to pass Mr. Copeland, if not early afternoon. That is the goal, by early afternoon to pass Mr.
Okay.
Copeland.
Understood. Thank you.
All right.
Bullshit.
All right, doesn't seem like there's anything else, so I'll see y'all at 9 tomorrow. Thank you.
All right, folks, that is day 116. That is day 116. That is day 116. Oh. Yeah. I thought today would be a little bit more interesting. But oh no, we're nowhere near done with the trial. Oh no, Travis, we are nowhere near. The judge anticipated 30 weeks, which would bring us to June? No, that's 40 weeks. April? The way the prosecution handles this, we will be nowhere near the end of the actual complete trial by April. But who knows? What I do know is that I will do my utmost best to be back here in Atlanta, though, for closing arguments. I have to try. I can't guarantee it because I need vacation days and all of that stuff. But yeah, I mean, today was productive, but maybe not as interesting as I hoped for. But you gotta have those days as well. You gotta have those days. And yeah. What you know what? not saying too much, but again, tomorrow I will probably be out all day. So I do not know if I can do a recap of tomorrow. Friday, also a full day, but Friday is Friday panel show. I will invite all the usuals and Phil as well. I hope I can get AV to the 7th power on here. I hope Doug will show up again. He keeps telling me each week to keep inviting him. Sooner or later he can join. But it will be a good group of people. And also the Wheel of Regrets. Yeah. So, okay, tomorrow I simply don't know. Friday, definitely Friday panel show. Friday panel show. So everybody, thank you for being here. Thank you for allowing me to do this. Thank you for sponsoring my trip to the United States. It's been amazing. And hug your family. Unless your family's crap, then screw them and give your love to the people who deserve it. Hopefully, you will be sent off to potentially criminal Sean. But until then, see you later, folks. Bye-bye.
I came from Sweden, drives across the land. Steel is grip, axe in his hand. Georgia lives his desire. Cryptic funny lets out a cry. Battles from east under the southern sky. Falling falls with a mighty sigh. Tennessee calls whiskey so smooth.